Good afternoon everyone and welcome to the 22nd Annual New Zealand Law Foundation Ethel Benjamin Commemorative Address. My name is Shane Milne and I am the current convener of the Otago Women Lawyers Society. It's my pleasure today to introduce Her Honour Chief Judge Jan Marie Doogue, Chief Judge of the District Court. I'd like to thank the following people for attending today: members of the judiciary, especially those who have travelled to be here today, Queen's Counsel from Dunedin and also those of you who have travelled, last year's speaker, Professor Nicola Peart, members of the profession and fellow owls, especially our much-cherished life members Kate Walker and Judith Medlicott, representatives from the New Zealand Law Society, the Vice-Chancellor of the University of Otago, Professor Harleen Hain, fellow convener of the Wellington Women Lawyers Association, Steph Dyberg, members of Parliament and City Councillors. Since 1997, the Otago Women Lawyers Society has held the annual New Zealand Law Foundation Ethel Benjamin Commemorative Address in honour of Ethel Benjamin, the first woman to be admitted in New Zealand to practice here in Dunedin on 7 May 1897. This annual event would not be possible without this generous support we receive each year from the New Zealand Law Foundation. We also thank the Williams Trust and the University of Otago Law Faculty for its continued support. The primary objectives of the New Zealand Law Foundation Ethel Benjamin Commemorative Address are to honour and preserve the pioneering spirit possessed by Ethel Benjamin, encourage education and achievement in the women of today, and stimulate debate about issues affecting social justice and gender. This address has been presented by the highest calibre of speakers, and today, of course, is no exception. Her Honour Chief Judge Jan Marie Doogue was appointed a District Court Judge in 1994 with a family court warrant. In 2007, she was granted a jury warrant and was appointed an alternate Environment Court Judge in 2011. Chief Judge Doogue was then appointed the Chief District Court Judge of New Zealand in September 2011, and she leads a bench of 166 judges. Chief Judge Doogue has worked on various committees in The Hague since 1999 and is the only New Zealander to ever be chair of a drafting committee in 2003 to 2007 and president of a final commission in 2009. Chief Judge Doogue has taken a particular interest in family violence issues, having presented papers on psychological abuse and the response from the family court, and on domestic violence and sentencing. In 2016, Chief Judge Doogue initiated a sexual violence court pilot in the District Court with emphasis on improving the court experience for participants through tighter pre-trial case management of jury trials and enhanced specialist education for judges. Chief Judge Doogue has been a great supporter of the annual New Zealand Law Foundation Ethel Benjamin Commemorative Address in the past, and it's an honour today for me to introduce the Chief Judge of the District Court, Her Honour Chief Judge Jan Marie Doogue, to deliver her address entitled Generations of Disadvantage, a View from the District Court Bench.
Ina mana, ina waka, ina reo, tēnā koutou, tēnā koutou, tēnā koutou katoa. It's my privilege and pleasure to give the address at this auspicious occasion. Māori have a proverb, a whakatauki, that encapsulates the career of Ethel Benjamin. Ka kuhu au ki turi, hei matua mō te pani. I seek refuge in the law, for it is the parent of the oppressed. Ethel Benjamin took refuge in the law to help the disadvantaged. It was telling that in her graduation speech in 1897, which she gave on behalf of all graduands, the first time a woman had ever given this speech, that Ethel chose to quote the English novelist and feminist Sarah Grand, saying, "It is the rebels who extend the boundary of right, little by little, narrowing the confines of wrong and crowding it out of existence." 2 years later, in 1899, Ethel effectively started putting this into practice. She became an honorary solicitor for the Society of the Protection of Women and Children. She took on a number of female clients, attempting to ensure that justice was done for those who had no voice. Her caseload included spousal abuse, separation, divorce and adoption, all areas of the law in which women were at that time disadvantaged, and sadly many still are. In 2018, I feel confident that Ethel Benjamin would have been fighting to end all forms of disadvantage, and it's disadvantage that I want to talk to you about today. I want to speak about disadvantage, or a synonym, vulnerability, from a unique perspective, from the perspective of being the Chief Judge of the District Court, and from the perspective that District Court judges, of whom there are quite a number of here today, see day in and day out. And I want to talk about how judges consider, deal with and respond to this vulnerability in the people that they serve in the limited way that they can. What do I mean by disadvantage in this context? It is the circumstances that set people up to make bad choices, and once they've taken a wrong turn, to restrict their ability to change direction. Those circumstances range from material, cultural and spiritual poverty to mental impairment and illness, substance abuse and addiction, and exposure to sexual and family violence. Disadvantage is commonly a multi-headed hydra, where many or even all of these factors are at play. Now, I hope to convey two key messages. The first is that the role of our courts, particularly the District Court, has evolved beyond the traditional decision-making or adjudicatory role. Our courts are having to engage in social justice more than ever before, and they are joining in the search for solutions to many of society's malaise. As a society, we need to accept this and embrace the reality that holding people to account requires a more sophisticated approach than simply finding wrong, attributing blame and imprisoning. As judges, we have a valuable contribution to making a break or disrupting the trajectory of disadvantage, and to help people, whether they are defendant or victims, restore their lives. To deliver justice effectively, there needs to be a more holistic view of what justice looks like, at least in my court. The second message I hope to convey is that in spite of the court's efforts and the judge's efforts in many instances, intervention once a case reaches our court is too late. A comprehensive, multifaceted response is needed, and very early on. As the saying goes, an ounce of prevention is worth a pound of cure. Of course, I'm unable to offer you the solutions today. That's beyond what any one judge or one group of judges can do. But what I want to do is share our perspective with you and hope that the fair winds of change and these subject matters will inform the kōrero that I think New Zealand has to have. The ultimate decisions on how we make society better are for others, those who have been elected by the people in Parliament. But we will continue to use the law to assist disadvantaged individuals in whatever jurisdiction of the District Court. Now, in the criminal court, that could be the complainant, it could be the victim, it could be the defendant. In the family court, it could be a child who's been removed from their family. It could be someone suffering from mental illness, or it could be the vulnerable elderly suffering from economic or familial oppression. Just some facts about the District Court which I don't think are widely known. It has the widest jurisdiction of any court of first instance in the world. Everyone entering the criminal justice system will have their first appearance in the District Court, or depending on their age, in the youth court or the adult court. All litigated family disputes, likewise, are held first in the District Court. And we have jurisdiction up to $350,000 in the civil court. So the District Court is usually the first and last point of contact for New Zealanders with their court system. Now, I don't mention these statistics to promote the District Court, rather just to give you an insight into the cases that judges deal with daily in our court. It deals with everyone, from the unborn to the elderly. It deals with cases that touch on almost every aspect of New Zealanders' lives. It is very much the people's court. I truly believe that there are few people as in touch with the painful realities faced by those coming to the courts as district court judges. Every day they hear from and speak to victims of crime and broken families, from people suffering addiction and mental illness, and from defendants and victims alike who are products of vicious cycles of family and sexual abuse. District court judges see what Justice Fata referred to in a recent judgment as the multiplicity of overlapping factors, including deprivation, trauma, youth, drug and alcohol abuse, and mental health issues. Now, from my vantage as Chief Judge, I do not see any single agency or department that is placed to fully appreciate this, to fully appreciate the effects of disadvantage in our society. I don't see any single agency or department that truly gets a holistic view of a disadvantaged person, but district court judges do. They have a cradle-to-grave view of society's illnesses. We see all the dots, and it's inevitable that we would eventually start to join them up. So what insights do we have that could contribute to our society being a better, fairer and more decent place? People often look to the youth court for that insight, to see the seeds of adult crime. Well, I'm going to say to you that in fact the starting point is long before that, and in terms of entering the justice system, it's the family court. There we see a cycle of alienation, hardship, disempowerment, tragedy, that ultimately lead from the family court into the youth jurisdiction and then into the adult court. And it's disturbing to observe that the outcomes are just frighteningly predictable. The judges of the district court have a joyless ringside seat to all of this. So, it's in the family court that it presents first in the form of care and protection proceedings under the Oranga Tamariki Act, and this accounts for 15% of the cases in the family court. Applications for protection orders in family violence situations are 13% of the work. And although family violence proceedings make up a very small proportion of overall business, family violence pervades almost every area of the district court's work. Where the family court considers that a child or young person is in need of care and protection, a declaration is made that the child should be placed into the care of the Chief Executive of Oranga Tamariki. I just wanted to pause because what you're about to hear is sobering. At the end of May this year, there were a record 6,300 children in the Chief Executive's care. The figures tell us, therefore, that our most vulnerable children and young people are being put into state care faster than ever before in our history. A significant portion of these children and young people who need a sense of stability and normalcy more than anything else do not receive it. Between 2013 and 2017, 40% of children and young people in state care had had at least 3 caregivers. This is in spite of research that suggests a secure placement coupled with continuous and quality relationship with a foster parent can avert the onset of criminal behaviour. Predicted criminal behaviour amongst those in state care also paints a grim picture. These children are 15 times more likely than their peers to have a subsequent record with the Department of Corrections. In fact, half of young people with past care and protection history and more than a quarter are predicted to offend in the next 15 years. And these people make up only 3.6% of the population, but are predicted to commit 12% of the offences in that time frame. Little wonder then, is it, that 17% of all prisoners and 13% of all serving community-based sentences had a care and protection event by the time they were 17. It's even worse for young offenders in prison. More than 4 out of 5 under the age of 20. 4 out of 5 under the age of 20 have been in state care. And the resulting negative impacts are disproportionately felt by Māori, who make up 2/3 of children and young people in state care. These statistics show that the state care system historically has failed those that it was designed to protect. The dissolution of Child, Youth and Family and the establishment of Oranga Tamariki acknowledged this. Nevertheless, family court judges see desperate and dangerous care and protection cases every day, and they are often left with no choice but to place children into that framework. Offending patterns amongst children and young people with a history of state care are chronic, and they persist into childhood, which is when we see them in the adult jurisdiction. It is said that most criminals are made, they are not born. Many of the children who first come to the state's attention do so in the family court. Children who are brought up in the most disturbing of circumstances become the potential offenders of tomorrow, and the sad fact is that some of them even come before that court before they are born. So, historically, the thesis has been that we need to fix our criminal justice system. Well, while this should undoubtedly form part of society's response to disadvantage, I would argue that it should not take centre stage. The brutal reality is that by the time someone appears in our court, weighed down and damaged by years of disadvantage and hardship, there is only so much that the judges can do. That's not to say that there is no hope, because there is. It's only to say that by that stage, the road to recovery and rehabilitation is considerably more arduous. Accordingly, we need to be focusing our resources at the genesis of these problems, targeting disadvantage at its source before its effects become entrenched. It's clear from the statistics that the most pressing need for action relates to Māori, and Māori who are in the care and protection system. The origins of the Oranga Tamariki Act lie in a 1988 report by the Ministerial Advisory Committee on a Māori Perspective for the Department of Social Welfare, entitled Daybreak. The committee recommended that Māori values, cultures and beliefs be incorporated into future welfare policies, and regard be given to the desirability of Māori children remaining within whānau, hapu and iwi. Commenting on the disadvantage faced by Māori, the committee noted, rather boldly for that time, 1988, there is no doubt that the young people who come to the attention of police and the Department of Social Welfare invariably bring with them histories of substandard housing, health deficiencies, abysmal education, and an inability to break out of the ranks of the unemployed. It is no exaggeration to say, as we do in our report, that in many ways the picture we have received is one of crisis proportions. To redress the imbalances will require concerted action from all agencies involved. Our problems of cultural imperialism, deprivation and alienation mean we cannot afford to wait any longer. The problem is with us here and now. Well, the problem is still with us here and now. That report resulted in the new Act. From next July, this Act will include tikanga Māori concepts of manatama iti, whakapapa and whanaunatanga. It will establish as principles the need to consider these concepts at the heart of any decision made in respect of any child or young person, as well as the need to take a holistic approach in decision making. And it will impose very serious duties on the Chief Executive in respect of Te Tiriti o Waitangi. This includes ensuring that the policies and practices and services of the Department have regard to the concepts and the whanaunatanga responsibilities of the child or young person's whānau, hapu or iwi. And the Act will augment the role to be played by those organisations. In light of this, it's crucial that all of our judges are culturally competent, and this includes the necessity to understand the key tikanga Māori concepts that will come into force, as well as ongoing education in tikanga and te reo Māori. Our judges will need to be able to be provided with the evidence both to understand the disadvantage that those children and young people have faced before they appear before them, as well as to recognise how whānau, hapu and iwi can be part of the solution. In order to draw from the mana of a child's whānau, hapu and iwi, the family court will need to make greater use of cultural reports and lay advocates, both of which will assist in providing judges with pertinent information to inform the most suitable outcome. Additionally, ensuring whānau and social work engagement at family group conferences and mediation conferences will help the court craft a plan that is in the best interests of the child. Utilising iwi capabilities where available may equally provide alternatives to traditional state care. This, of course, will depend on iwi resources. However, greater iwi involvement in the justice system is to be encouraged, in my view. It is heartening that the Children's Commissioner earlier this month released a report discussing the upcoming changes to the Oranga Tamariki Act with a particular focus on the Chief Executive's obligations. The Commissioner advocated for a kaupapa Māori approach to state care, arguing for the upcoming law reform to bring with it an opportunity to partner with hapu and iwi to transform the outcomes of tamariki, whānau and Māori. I agree entirely. Given the overrepresentation of Māori in the state care system, it's time to acknowledge that we need to address the issue in a different way, with hapu and iwi in partnership. These changes to the law will also require family court judges to rethink the way some things are done in the court. For example, judges will have to reflect on the appropriateness of permanent custody orders as opposed to interim custody orders with periodic review. In fact, judges will need to give thought to whether or not care options other than those involving whānau, hapu and iwi actually comply with the amended principles of the Act. Finally, there is a case for changing the way in which care and protection matters are considered. Currently, some reviews are done in chambers and on the papers, and that's been a necessary response to the workloads of the family and district courts. And it is often the case that the judges do not have the family and whānau in the courtroom. This is because the final decision comes after the mandatory family group conference where all parties are present. However, if we are to stay true to the Act's expanded principles, it may be that care and protection reviews will be done kanohi e te kanohi, face to face. This would involve whānau, hapu and iwi with a greater opportunity to be heard, something which carries immense cultural and moral value. What is clear to family court judges is that state care can have disastrous implications and can greatly increase the risk of offending. So, state care is not the only marker for entry into the criminal justice system. In our courts, judges see a plethora of disadvantage, poverty, homelessness, family and sexual violence, family gang affiliations, addiction and mental health issues. Turning first to family violence, a recent review of around 16,000 young offenders in New Zealand found that 80% of them under the age of 17 had experienced violence in their homes. 80%. In fact, in 2016 and 2017, nearly 9 out of 10 offenders aged 14 to 16 had had one or more prior care and protection reports made. In 80% of police call-outs to family violence, a child is present. Tens of thousands of New Zealanders are growing up in a climate of violence. and violence in one generation is positively correlated to violence in the next. 77% of all adults in the criminal justice system have been victims of family violence, and almost half of all prisoners have experienced family violence as a child. In our criminal courts, it is clear that violence breeds violence. It sets those who are abused up to be the abusers. Equally prevalent is substance abuse and addiction. A staggering 2/3 of young people in youth justice residence meet the criteria for a substance abuse disorder. Even more are reported to be heavy drinkers. These figures are worse for Māori, who on average start using alcohol and drugs from a much earlier age. Substance abuse is a major driver of crime. It is estimated that 9 out of 10 prisoners have a substance abuse disorder. Like violence, substance abuse and addiction are a common marker of disadvantage in the cases before our judges, and then layer on top of that the mental health issues. Between 50 and 75% of youth involved in the justice system meet the diagnostic criteria for at least one mental health disorder. Those in youth justice residence have 10 times a greater likelihood of mental health disorder than youth generally. And as a recent study concluded rather chillingly, in New Zealand youth justice residents, some form of psychological need was the rule rather than the exception, and the pattern repeats in the adult jurisdiction. More than 1/3 of offenders have a mental illness. 9 out of 10 prisoners have a diagnosable lifetime mental illness or disorder, and this is more than twice the rate measured in the general population. Meanwhile, science is teaching us about more forms of mental impairment underlying offending. Our criminal courts are increasingly faced with what the Principal Youth Court Judge John Walker has called a cocktail of disabilities, that is, neurodisabilities and learning disabilities. This form of disadvantage is not always obvious, and the conditions are often referred to as hidden disabilities. These disabilities include ADHD, autism, traumatic brain injury, epilepsy, and fetal alcohol spectrum disorder. And although neurodisability is not new, the spotlight really hasn't been turned on it in terms of the criminal justice system. In 2012, the Children's Commissioner for England reported that neurodisabilities were overrepresented in the youth offender population. In the UK, youth offenders were 10 times more likely to have some form of learning disability, and 60 to 90% of them had some form of communication disorder, and 11% of them were reported to have fetal alcohol spectrum disorder. The prevalence of neurodisabilities is equally high in adult offenders. Here's another shocking statistic. 95% of female prisoners and almost half of all prisoners have a traumatic brain injury, and 70% of them have significant literary problems, a strong marker of future criminal offending. The high prevalence of traumatic brain injury and fetal alcohol spectrum disorder is a particular concern of district court judges. They can cause a person to experience a range of cognitive impairments and socially challenging behaviours, including poor memory, concentration, a reduced ability to plan, as in make a court date, an inability to problem solve, and lack of consequential decision-making, and a reduced capacity to regulate emotion. So consider then the defendant who repeatedly does what they're told not to do, such as breach bail conditions or a protection order, because they don't understand the implications of their actions. The defendant who appears sullen and non-cooperative because they feel, and indeed are, dislocated from the process happening around them. These neurodisabilities will negatively impact on their fate in the criminal justice system, which is, after all, a system that demands compliance with rules and processes. Particularly worrying is the disproportionate number of Māori in our criminal justice system. They accounted in 2016 for 2/3 of people appearing in the youth court. When the prison muster reached a record high of 10,645 earlier this year, half of those inmates were identified as Māori, despite Māori comprising only 15% of the general population. This figure is around 60% in the female prison population. So overall, Māori are 6 times more likely to be imprisoned than non-Māori. And consider this, the female prison population has been increasing at almost 3 times the rate for men in the last 5 years. It's estimated that the vast majority of our female prisoners are mothers. Vast majority of our female prisoners are mothers, and you get the intergenerational dynamic right there. We know that a parent in prison is 10 times, we know that a child with a parent in prison is 10 times more likely to end up in prison themselves. So the dots I can see on your faces, the dots are lining up. Māori also disproportionately feature throughout the criminal justice system, not just in prisons. 42% of all criminal proceedings and 41% of all convictions. These are paralleled by high numbers of victims who are Māori. As the Waitangi Tribunal noted in a recent report, whatever measures were presented, the rates for Māori are invariably worse. For most New Zealanders, having any contact with the criminal justice system is rare. But sadly, for some communities, it's a normal part of life. And these figures speak to the long history of intergenerational disadvantage suffered by Māori. It's been 15 years since the late historian Michael King wrote of the cycle of disadvantage exacerbated by urbanisation of Māori in the 1950s. Māori as a group were younger, less skilled and paid considerably less than Pākehā, and he observed, all these factors combined to make Māori more vulnerable as a group than Pākehā when wool prices fell a decade later and ended full employment. They created a cycle of circumstance that was self-reinforcing and difficult to break. Lower standards of educational attainment led to lower incomes or unemployment, which led to lower standards of housing and health, which led to higher rates of crime, which led back to lower educational attainment, and so on. Today, I believe there is a growing acknowledgement of the shameful story behind these statistics, of the toll that has been taken on Māori. The figures I spoke of are finally focusing minds. A consensus appears to be building on finding alternative approach to prisons, famously described as a moral and fiscal failure. The recent convening of a criminal justice system is an example of this more progressive and collaborative thinking. As judges who see the cycle of disadvantage on a daily basis and dispensing the law is a disenchanting exercise in déjà vu. Time for a reset is long overdue. It's no surprising then that the most pressing need in our criminal courts relates to the over-representation of Māori. And as in the family court, this places an obligation on our judges to be culturally competent. In the criminal jurisdiction, this requires judges to be receptive to the relevance of cultural information about the defendant presented in pre-sentence reports. And where it's not already been presented, counsel need to be more aware of Section 27 of the Sentencing Act and the option of calling for a cultural speaker to address the court on behalf of the defendant about relevant cultural matters at sentencing. Cultural information can be relevant in 2 ways. One, it may mitigate the defendant's culpability, or it may impact on the relevance of sentence. Cultural information also insists on dimensionalising the defendant. It gives the court necessary information to piece together a greater sense of who the defendant is, and particularly whether that person's conflict with the law is actually driven by disadvantage, neurodisability or some other form of disability. Additionally, it also helps to extend and acknowledge the suitability of Māori solutions to Māori offending. For example, when imposing a sentence of supervision or intense supervision, a court may also impose special conditions related to attending certain types of program. A program includes placement in the care of any appropriate agency approved by the Chief Executive of Corrections, including agencies which are regulated by whānau, hapu or iwi. This rehabilitative sentencing option seeks to place the offender into a community environment with positive influences. It also acknowledges the strength and resources of Te Taha Māori, the Māori identity. Of course, such an option relies on adequate hapu and iwi resources and capability. And iwi, if they were here, would tell you that some of them are ready for the challenge and some of them are not yet. Another one of our criminal court's priorities is the treatment of young adult offenders between the age of 18 and approximately 25, because we know, the neuroscience tells us, that the brain, particularly in men, is not fully formed until about 25. So some of the risk-taking and the criminal behaviours are actually regulated by physiology and not necessarily by informed choice. The Youth Court already has a solution-focused court with this in mind, with 5 different government agencies represented in the courtroom in most of our larger courts. Solution-focused courts provide a non-adversarial, coordinated and multidisciplinary response to offending, and this has proven to be highly effective for mitigating the risk of reoffending. However, when a person turns soon to be 18, they enter the district court where this wraparound approach does not exist. They're treated like fully competent adults and are expected to understand the court process. Yet these people continue to carry the disabilities they may have had since childhood, together with those that they have gathered along the way. And disabilities don't have an expiry date. They don't expire when you turn 17, and they don't simply disappear when you enter the adult court. Research shows us that they have demonstrably different brain architecture. They are more likely to be impulsive, short-sighted. Any of you who are presently parents of teenagers will relate to this. Responsive to immediate rewards and less likely to consider long-term consequences. Cognitive and emotional underdevelopment significantly impacts on crime. In 2017, one-third of all people convicted were between the age of 17 and 24. And this group accounts for 17% of the prison population. Although research shows us that at least one-third of all young people will engage in some form of serious criminal behaviour, at least half will age out by the time they're 23. If we truly seek to stamp out recidivism in young adult offenders, I think we must first acknowledge that their actions and their decisions may be mitigated by their lack of maturity. Sanctioning them, like fully mature adults, could have lifelong consequences that do more harm than good to them and our communities. And the evidence around this needs to be reflected in our court procedures. Procedural fairness leads to defendants having a better understanding of court processes, opportunities to express their voice, a sense that decisions are made by impartial arbiters, and a feeling that regardless of the outcome, they have been shown respect. Adopting an approach that is more cautious and treats all people as though they could be vulnerable, they could be suffering these disabilities, in their interaction with the criminal justice system, in my view, would benefit everyone. This universal vulnerability approach can be as simple as using plain language, open-ended questions, asking people to repeat back the information that you've given them in their own words. This approach zeroes in on what is important in the interaction, whether the communication is effective, understood and therefore fair. An approach that better deals with disadvantage also requires giving the district court judges who are dealing with this cohort the same range of tools that are available to the youth court. Numerous overseas jurisdictions are already doing this. If our judges can make a difference in the life course trajectories of this group through some sort of wraparound services by using appropriate processes already available to us, there's every chance that fewer will go on to be recidivist offenders. In an ideal world, all courts such as ours would provide wraparound services and shift from solely decision-making to include solution finding, and this is precisely what our specialist courts do. Courts like the Matariki and Rangatahi courts address the underlying causes of Māori offending. Pacifica courts do the same for Pacifica. The alcohol and drug treatment courts aim to address evidence-based treatment as well as applying the criminal justice framework. And in the specialist circumstances court and the Court of New Beginnings, offenders are provided with solutions to their homelessness. Imagine if these courts did not exist just on the margins. Imagine if this holistic, solution-focused approach was integrated across all of our courts. Of course, to be holistic, we also need to be truly mindful and responsive to the needs of complainants and victims. We've all been told for a very long time that the criminal justice system ignores, disrespects, and even re-traumatises victims, that it just treats them like evidence. Legally trained people have no difficulty understanding that court processes are designed to impartially consider and test evidence brought by the state on behalf of the community. The criminal justice system does not callously set to sideline victims, but unfortunately we're told that's how it feels. We're beginning to better appreciate how the system's processes are good for testing evidence and protecting fair trial rights, but struggle to meet all of the needs of victims. My response to this is that the District Court is striving to be more mindful, without compromising the integrity of our impartial system and the presumption of innocence. If handled carefully, the two are not mutually exclusive. For instance, the Sexual Violence Pilot Court is demonstrating how judicially led improved case management and best trial practice can make court processes gentler on everyone involved. However, recognising the underlying causes of offending and adapting our processes, in my view, holds the true prize for victims and indeed for all New Zealanders. So this takes me back to the very beginning, to the family court and those families that are in crisis. We all stand to lose when state intervention in those families leads the vulnerable to offend. Or, as a veteran court reporter recently described it, it's one thing to hear about the effects of abuse and neglect on a child, it is another to see it manifested in a sad, angry, and lost human being standing before you in the dock. Given these depressing familiar patterns, more investment in the family court's care and protection work is warranted. The Ministerial Advisory Committee's words I spoke of earlier apply as much as they did in 1988. Family court judges see the deprivation and disadvantage. We don't want to see or be here in another 30 years with another Chief District Court judge talking about the cycles of disadvantage and yet more sad, angry and lost human beings. Our primary focus needs to be on the feeders of the criminal justice system where the effects of disadvantage begin to take hold. If the District Court and its judges are to effectively engage in social justice, we cannot do it alone. It will require resources to be allocated strategically across the whole of government to ensure that there is a greater impact on the people coming to court. There is an opportunity to drastically improve outcomes for these people if we invest early in more effective intervention. This has the potential to affect generational change and to decrease the risk of the system producing future offenders. Now, I am the first to admit that it would require a Rolls-Royce funding model to completely transform our justice system. And I know that with the greatest will in the world, government only has a certain number of resources. I've tried to stretch our judicial resources to places that unfortunately cannot reach. Remedying this is beyond my control, but in the district court, we get a clear view of this precarious landscape. The corrosive, long-lasting effects of it is irrefutable. So the approach that I've outlined today in the district court, we do try within our limited resources to address disadvantage, having education for judges on cultural competence, to constructively adapting and interpreting the amendments to our care and protection legislation, making greater use of cultural information in respect of children and young people at sentencing, making greater use of whānau, hapo and iwi alternatives to state care and imprisonment, and having a greater appreciation of the place of the brain's architecture and neurodisabilities in the offenders we see. So in conclusion, people who appear in the district court are in crisis. Their families are in crisis. The victims of their offending are in crisis, and their loved ones are in crisis. And they should be able to look at a court that is understanding, empathetic and insightful. For the court to make life-changing decisions, it should first be attempting to cut through the isolation, hostility and alienation. The court system needs processes that offer hope to people who may well be at their lowest points. Hope that things which have gone so disastrously wrong will start to come right, no matter how long and arduous the journey towards restoration and rehabilitation may be. In the district court, judges are uniquely placed to witness the life cycle of family and social breakdown. We cannot genuinely, any longer, uphold the role of wise adjudicator and decision maker without having processes that address the growing evidence of the underlying causes of offending. We cannot close our eyes and ears merely because it would be inconvenient to a justice system which has timelines and targets. The district court may have a unique long-range vantage point, but we do not pretend we can address these challenges without you. The repeating cycles of disadvantage are showing up in other settings, schools, hospitals, workplaces and welfare agencies, all of our communities that intersect with the lives of those spiralling towards conflict with the law have opportunities to intervene. What our specialist courts have demonstrated is that when groups work together to find solutions and alternatives to traditional responses, then reform and rehabilitation are more than a forlorn hope. Of course, none of this diminishes our paramount role as judges to interpret and apply the law impartially. Knowledge is the soundest foundation on which to make decisions, and the holistic approach I've outlined enriches that knowledge. It breathes humanity and vibrancy into the written law. By transforming our court processes to better account for the complex needs I've outlined, we honour the pursuit of justice and those we serve in the People's Court, that is the District Court of New Zealand, and we honour the memory of Ethel Benjamin. Nō reira, tēnā koutou, tēnā tātou katoa.
Good afternoon, and thank you all for coming to the address today. I'm Karen Billinghurst, the Deputy Convener of the Otago Women Lawyers Society. A very warm thank you to Chief Judge Doogue for being our 22nd annual New Zealand Law Foundation Ethel Benjamin commemorative address speaker today. We greatly appreciate you taking up our invitation. I'd also like to acknowledge some members of your team who are so easy to work with ahead of your visit to Dunedin, so thank you also to Tanya, Stephen and Milan. Today we've been privileged to hear a powerful, informative, facts-based and forward-focused address. And we're grateful for the statistics and insights you've shared with us that allow us into the working world of the District Court to better appreciate the day-to-day challenges that you and your team face. We got a real sense of the impossible circumstances the District Court is sometimes balancing when making decisions which hope to contribute to better outcomes for New Zealanders. Some of the statistics were shocking and sad, especially around issues affecting children, women and Māori. And I felt that they would be not too dissimilar to the same problems in Ethel Benjamin's time. However, as you said, the time for a reset around the crisis of disadvantage is long overdue. So it's incredibly positive to hear the District Court's response is to take a joined-up, inclusive, culturally competent and solutions-focused approach to adapt to legislative amendments and to better appreciate underlying health issues in order to try and improve those statistics. Being able to adapt and respond in a relevant, mindful and practical way to resolve issues affecting one's own profession is something we can all relate to. And on behalf of OWLS, I acknowledge and thank you for leading a strong, resilient approach here. It's an OWLS tradition to present our address speaker with a specially handcrafted brooch of an owl made in Dunedin by well-known jeweller Tony Williams. Tony has semi-retired, so this is now perhaps a rare owl. Thank you again, Chief Judge Doogue. Okay, I'll carry on. We usually have a representative from the New Zealand Law Foundation to speak at the address, but unfortunately they weren't able to attend and send their apologies, so I've been asked to read out the statement. The New Zealand Law Foundation is proud of its unbroken 22 years of support for this annual address and will continue its association with what has become a very important and eagerly anticipated annual event. We acknowledge and thank Chief Judge Doogue for this year's excellent address. In addition to this annual address, the Foundation maintains a strong relationship with the City of Dunedin through the projects we fund, and we've got a fine record of successful and substantial research through its relationship with Otago University. We have close to $1.5 million of projects currently being funded through the university and other Dunedin institutions. 3 examples of substantial groundbreaking legal research include the work being led by the Donald Beasley Institute to establish a national online resource for legal professionals who work with vulnerable witnesses and defendants, which will launch next month. The Law Faculty and Children's Issues Centre work evaluating the impact of the family law reforms, which we're eagerly anticipating, and the multidisciplinary study jointly led by the faculties of Law, Philosophy and Computer Science, looking at artificial intelligence and the law, with a focus on predictive analytics, machine learning, the future of the professions, particularly law, and machine morality, all issues of significance for our future. The Foundation trustees also want to pay tribute to the Otago Women Lawyers Society. They are to be congratulated for the professionalism with which they organise this event each year, making it a nationally recognised event of such significance. So thank you to the Law Foundation for those kind words. Finally, Shane and I, on behalf of the OWLS Committee, would like to thank our sponsors, the New Zealand Law Foundation, the University of Otago Faculty of Law and the Williams Trust. Also, thank you to the Dunedin Public Art Gallery, the Inspired Pantry Catering Company and the Impressions AV team. And we're supporting Women's Refuge today by donating all the leftover food from the afternoon tea. I thought you might like to know that. But please feel free to indulge as you would normally. Before we conclude the event, I'd like to come back to Ethel Benjamin and touch on 2 interesting facts which I think speak volumes about the woman we're commemorating today. Clearly, Ethel was a determined, intelligent leader in order to have become New Zealand's first woman lawyer in the 1890s. But she also continued to evolve in her career, and after moving to England in 1910, she became England's first bank manageress for Midland Bank in Sheffield during World War I. And then, in fact, I particularly like, she chose to live in Italy and the south of France between the wars. So today we honour the woman who was ahead of her time, clearly, in terms of owning her career, continual self-development and her own focus on well-being. And on that note, I'm pleased to conclude the address, and I'd like to invite you all to join us for afternoon tea in the gallery next door. Thank you.